1173. Good morning, Representative Burleson. You're right.
Good morning. Thank you, Mr. Chairman, members of the committee. Mr. Chairman, you missed the squirrel biscuits and gravy breakfast. I apologize. I know you remember the Sportsman's Caucus, but I'm sorry that I didn't see you there. For the members of the committee, my name is Eric Burleson. I represent the 133rd District, which is in southwest Missouri, Springfield, town of Battlefield, and a little bit of Republic. And this bill should be very familiar to the committee. It is the exact same bill as last year, which passed the House, made it to the Senate. Unfortunately, did not make it all the way through the process. But this is dealing with an issue related to the elimination of caps for non-economic damages that occurred recently. You know, Missouri has had a long history of establishing caps for non-economic damages, and it has established constitutionality of those caps. And in 1992, the court upheld those caps in a 6-1 vote in the case Adams versus Children's Mercy Hospital. But in the recent ruling, Watts v. Lester E. Cox Medical Centers, not only did they overturn the Adams decision and previous decades of court rulings, but they, in essence, did it in a unique way where they challenged the authority and the power of the General Assembly to define law and establish or attempt to enshrine English common law into today. Now, the majority opinion was using the word heretofore enjoy. So this is kind of a recap of last year. Maybe you still remember how this happened. But they used the phrase that's in the Constitution as heretofore enjoyed, and by making reference that because it had been enjoyed up until that time, they're referencing that it must have been enjoyed through common law, which was established in the Missouri statutes. And so the intention of this bill is to reestablish the first section of Missouri statutes where we establish common law, and because in essence what we're doing in the statutes, the very first section of statutes is common law, but the rest of our statutes are a but-for. In essence, we are saying we recognize common law, but for all of the things that we proceed to find in the rest of our statutes. And so, in essence, we're underlying the but-for, and that's what this bill is doing, is strongly underlining that we have the authority in the legislature to establish, we have the authority in the legislature to create cause of action for medical malpractice, to establish this, and we certainly have the authority to place caps on it if we're going to establish it. It is extremely important that we place caps. Consumers know how expensive maintaining personal health insurance is, and they are aware of the soaring premiums that we're experiencing not only in Missouri but all across the United States. The Missouri Department of Insurance in 2011, in their report, they noted that the number of individuals with pending claims or the claims at year-end had reached an all-time low in 2011. That 2011 low was after reaching a peak in 2005, before our caps had been put in place at 350,000. So after the caps had been put in place, we did receive a low, or we saw a decline in the number of suits that were filed in the state of Missouri. One of the things that you will hear is that the placing caps does not affect the amount of premiums or the costs, but that is clearly not the case. When the volume of claims are declining because of by us putting caps in place, we know that reducing that volume has reduced the cost for medicine and reduced the insurance premiums in the medical community. The goal is also to encourage job creation and relieve those who are working in Missouri's medical field. We know that in states such as Texas, where they have dramatically changed the tort system in Texas, They're receiving a flood of license applications for physicians in those states. And so when you talk to students that are graduating from medical school, where they're looking to go, Missouri right now is not a hospitable environment for providers in the medical community. So this bill, in essence, is similar to the one that was brought last year. I'm hoping that we'll have better success in the Senate than we did last year. There's a lot of people who come to give personal information about and provide personal testimony. And with that, I'd be happy to entertain any questions, Mr. Chairman.
Thank you. Questions? Seeing none, we'll start with some witnesses, just so we can get a rough idea. Show of hands of everybody who's planning to testify. Okay, great. We're glad you all are here. For all the witnesses, I'll give the same reminder. We do have witness forms at the desk in front. Please make sure you fill those out so that you can make the testimony a part of the official record. And with that, we'll begin with proponents of the bill. Good morning.
Good morning. Chairman Richardson, I'm Dr. James Wolf. I am president of the Missouri State Medical Association. I'm also a retired otolaryngologist, having practiced over 33 years in Springfield, Missouri. I obviously was practicing during the last malpractice crisis, where I saw premiums rise as much as 70% a year. Between 2000 and 2002, I also saw us lose over 300 physicians from Missouri. During that time, 1 in 10 obstetricians quit delivering babies. In Kansas City, Missouri, most of the neurosurgeons left and went to Kansas City, Kansas. So if you were involved in an automobile accident and had a head injury in Blue Springs, you had to be transported over to Kansas City, Kansas. As mentioned, after the tort reform legislation passed, all that changed. Since 2005, we've had a total of about 1,000 physicians come to Missouri. Obviously, that's going to change if we don't do something else. Malpractice premiums since 2005 have been decreasing at an average rate of 6% per year. God only knows what it's going to do in the future if we don't have some relief. In addition, Missouri patients are facing a potential physician shortage as a result of a perfect storm. That perfect storm is a combination of the July 31st, 2012 Supreme Court ruling on non-economic caps. In addition, we have an aging population. We have the effects of the Affordable Care Act, and as mentioned a little bit ago, there are massive debts for our medical students at graduation. This is all combining to produce a potential shortage of physicians.